Here's what I think about punitive damages and willful conduct these days. I never try a case anymore on punitive damages. I never try a case on willful conduct unless it's just something blatant like drunk driving. If it's drunk driving, you can try a case, but I don't do it because for this reason. The appellate courts hate punitive damages. They will do everything they can to set them aside. You're far better off in most jurisdictions. You're far better off to put all that exacerbating evidence in that you can get in. Sometimes you can only get it in if you're pleading punitive damages, but if you prove a lot of choices available to the defendant that would have avoided this, then you're not asking for punitive damages. You're simply using that to increase the irritation factor, which they then apply as a multiplier to your general damages. Put this over here on your physical pain, mental anguish, physical disability, physical disfigurement, the general damages, because the appellate courts are much less likely to tamper with a general damages finding than they are to tamper with a punitive damages award. So, think in terms of purposive attribution. The defendant acted on purpose. Now, the other attribution, reactive attribution. Reactive attribution is that the defense, the jury will tend to forgive conduct, even possibly to the point of negligent conduct, if the actor is in a reactive posture as opposed to a purposive posture. So if you need to stress, especially on comparative fault. You stress the fact that the plaintiff was reacting, whereas the defendant was acting. The defendant, and here's where you come back to fundamental attribution. The defendant chose to act in such a way as to create the situation. So in fundamental attribution, whether they're looking at situation or whether they're looking at person, it's the defendant either way. The defendant chose to act in such a way that created the situation. It's the fact that he was driving 70 miles an hour in a 40-mile zone and decided to made the conscious decision to try to make it through that red light. That's purposive conduct. That created that dangerous situation. On the other hand, the plaintiff, who is being charged with comparative fault for whatever, was reacting. So you want to stress the fact that this reaction, the plaintiff is reacting to a situation created by the defendant. So those are the attribution. There's defensive attribution, which simply says that be cautious about accepting someone on a jury because you think they are just like your plaintiff and they will identify with your plaintiff. A very quick example on defensive attribution, because it's very, very important. Because it's so easy for us we would naturally be misled by it. We'd mislead ourselves by it. The defensive attribution is this. I had a case in which we had I-10 was being built. They were doing some construction work, and they just wiped out the backyards of all these kids. And it was Good Friday, and all the kids were out of school, and there had been torrential downpour. There had just been rain for a solid week, and they weren't working on the construction site. And they were sinking all these big poles where they're putting in the big highways. And they had all these 30-foot pits, and these 30-foot pits were filled with water. And these kids were all out. They're out of school, and their playground is gone. So they're out there playing in the back. On this particular day, it wasn't raining. They're out there playing outside. Long story short, one child falls into the pit. His brother jumps in to save him. Okay? The one child is, the first one that falls in drowns. The second one is brain injured. The mother, and the mothers of all the kids, same situation. The mother is in the house. Kids are playing outside. I did focus groups on this, and boy, did I I got a quick education. Immediate response. The men across the board, several of them had worked construction. Men on the focus group were coming up with great ideas about, boy, here's what the construction people should have done. They should have done this, and they should have done this. The women were what? Totally blaming the mom. So we did another focus group. We brought 24 people in. We got 12 women, 12 men, and we made the whole presentation, and then we divided them up into two groups of 12, and we put the men over here, got great feedback. The women over here, men never mentioned the mother, ever. Nobody ever raised an issue on the mother. The women never talked about anything else. Total fault of the mom. Okay, that is defensive attribution. Why are the women doing that? They're doing that because they are defending themselves. A mom, and the more similar a woman is, this is a woman who had two children. One was 7 years old, one was 11 years old. And so if you had a woman on the jury who had a child who's 7 and 11 years old, you think, she just might identify with this plaintiff. She might identify with this loss. No. What she's going to identify with is, obviously she did something wrong that caused this. Otherwise, what? Otherwise, this could happen to me. This can never happen to me and my children. She's defending herself. This can never happen to me and my children because I wouldn't do whatever it is she did. I would not have let my kids go out on that day, whatever. So that's defensive attribution. So it's a trap. Just be aware of it and watch for it. Power of choice. On the power of choice, what you want to do is you want to look. We always just make a list, and we'll put it up here. We'll say, okay, let's brainstorm it. Give me the defense choices. Everyone. Let's name every one of them, and we list them. Now, when we put the defense choices up, we now say, and this is important, as opposed to everything else I've said to you. We now say, okay, now convert this to positive action on the part of the defendant. You don't say the defendant failed to do this, the defendant failed to do that, the defendant didn't do this. You say the defendant chose to do this. You have to convert this to positive action. It has to do with communicating with the unconscious mind and all that, because the unconscious mind does not process negative information. So you want to convert it. So the doctor didn't fail to do this test. He didn't fail to do this test. He didn't fail to do this. The doctor chose to ignore this test. He chose to ignore this test. He chose not to do this. He chose instead to send this child home without proper testing. So convert, when on the power of choice, always convert the actions of your defendant to positive choices. Then you tie your choices back, as we discussed, back to the fundamental attribution. Okay, now when you're now down to the point where you can start thinking in terms of the concepts and how you're going to present this and how you're going to do your storytelling. And what I always try to do is I am a firm believer in focus groups. I've been doing focus groups since 1984. I did my first focus group because I attended a political focus group in 1984. And I watched these reactions, and I'm like, wow, if this works for politicians, why wouldn't this work for jurors? If it works for voters, why wouldn't it work for jurors? So we started doing focus groups in 84, and I am a firm, strong believer in focus groups. So I always test my stories. I test my theories, but let me tell you what you always test. Always test your physical evidence. Always test your demonstrative evidence. Always test anything that the jury is going to take into the jury room where they have it with them, where they can take it and look at it and say, wait, look at this. Oh, look, oh, did you notice this over here? Boy, make sure you know what jurors are going to see when they get in there, because they'll see things you can't imagine. So we had a case where we had myself, we had two different plaintiffs, two other plaintiffs' lawyers that were referring attorneys. We had 3 lawyers. We had like 4 people from my firm. And we had looked over and over and over and over at these pictures. And we're looking for what happened. Big controversy. What exactly happened in this tragic accident that killed a couple of people? And we had looked at it, and we had a photograph. Highway patrolman's photograph. And there were like 10 of them. And I did a focus group, and we're going through the photographs, and we're not telling them, we're just letting them discuss it. And this lady says, and we're talking 3 weeks before trial. I mean, we've had this case for 2 years. This lady says, well, it's obvious what happened. And really, what would that be? And she says, well, let me show you. She takes a yardstick, and she comes over, and she comes up to the screen, and she lays that yardstick on the screen. She said, here's the path right here. And we're like, damn, of course it is. Of course it is. And she was absolutely right. But I had 7 people, lawyers, professionals, looking at it, and we had never seen it. And it's one of those things that once she pointed out, you couldn't miss it. And she was absolutely right. And we tried the case on that theory. So I can't stress to you enough the importance of focusing anything that's going to be demonstrative, anything they're going to take in the jury room with them. Let focus group members take it in the jury room with them and see what they come up with, okay? The next thing, some concepts that I'm just going to mention to you in passing here. Primacy, recency, availability, framing, theming, and sequencing. You think in terms of primacy as, you get their attention. You grab their attention with the first thing you do. And you think in terms of, they pay closer attention, obviously, when you first begin something. So you use the concept of primacy absolutely everywhere. In every examination of a witness, you start with, your primacy should be, what am I going to start with? In your cross-examination, if your cross-examination begins with, now did I understand you to say, did you just testify that? The jury's saying, yeah, that's what he said. We heard it. No. Primacy. Go in and make your point. Have a point to make. That's primacy. Recency is you leave them with you close with a strong point. You do that on every witness. You do that you do it before every lunch break. You want the last thing they hear before they leave for lunch to be strong. That's recency. You want the first thing they hear after they come back from lunch you want to capture them again. So that's primacy. You want to start with that. And you certainly want to leave them at the end of the day with something strong, because thinking in terms of when they go home tonight and the spouse says, what'd you do in court today? Well, we did this. You want to leave them, you want to know what you want that to be. You want it to be your theme, and you want to make sure that they are your trial story, and you want to make sure that they're buying into it. Now, framing, how you frame questions is important. That's why you see all these stupid political You see all these stupid political polls. I mean, they're not stupid. They're smart. The people that believe them are stupid. You tell me what you want the answer to be, and let me frame the question, and I'll get you the poll results. You know? I mean, that's what pollsters do. So think carefully about how you frame your issues, how you frame your question. Sequencing is extremely important. You've got to you're telling your story now, but you have to think in terms of sequencing it. In what order do we present this? You want to, and putting that in with primacy and recency, you want to start strong. But do you want to, I always think in these terms, what is your outcome determinative issue in the case? It doesn't matter what my damages are if I lose on causation. It doesn't matter what my damages are if I don't carry this point on it being a defectively designed product. If I don't carry defect, nothing else matters. So I want to know what is or if I got a clear case of liability, then my big issue, my big outcome determinative issue, outcome in terms of the amount of the verdict, what's the issue going to be? What is the element of damage that's going to be the most outcome determinative? So that's where you want to think in terms of sequencing. You want to sequence in such a way that you make sure that you're putting the most important things exactly where you want them to be. If you need to sequence, for example, you need to sequence your evidence in terms of establishing liability. If it's not a clear case of liability, you need to establish your liability first before you start talking about your damages. Because if you put on you come in and you say, I got a strong damage case, I'm going to hit them with damages. I've heard this phrase, the damages will carry the liability. Not anymore, it won't. Maybe it would have. And if it will in your jurisdiction, call and let me come try a case there. Because damages don't carry liability anymore. Tort reform has I think, largely wiped that out. So you have to carry liability. But if you come in now and you start proving up damages in sequence ahead of liability, then they're sitting there wondering, first of all, why am I hearing this? Because what's that got to do with the guy sitting over there at the defense table? And secondly, you're playing right into the preconceived notion that they have of plaintiff's lawyers coming in there you're just going to come in here and try to move me. You're going to come in here and try to persuade me. So we have to go in and sequence in such a way that we establish, they have to know why. They have to know why they're hearing damage proof. So you have to come in strongly with your liability proof.